My name is my name is Alicia, and I'm the Plan Giving Manager here at Search for Common Ground. I'm so glad that you're here with us today. You've probably heard us describe Search as the world's largest peace building organization, but another way to think about it, and the one that I love, is that we're a global community of citizen peace builders, and that includes you. So by being here, you're showing that you care deeply about building a more just and a more peaceful world, and that means a lot to us. Today's conversation is about more than just legal documents or financial planning. It's really about the legacy that each of us leaves for the people that we love and for the future that we want to help create. And while this webinar is not intended to give legal or tax advice, we encourage you to consult your professional advisor about your specific situation. This session will provide you both with practical tools and inspiration for how your values can keep making a difference for generations to come. So today we're going to look at a few different things. We'll start with estate planning, why it matters, what plan giving actually looks like, and then we'll introduce FreeWill, which is a simple free tool to help you start the process if you haven't already, or to review and update your plans if you have. Then we'll talk briefly about some recent tax changes that might be useful for you to know. And from there, we'll look at the impact a legacy gifts can make for peace building. And if we have time, we'll wrap up with some questions as they come in. But thank you so much. I'm excited to be joined by Chuck Borick from FreeWill, who has a wealth of knowledge about estate planning and charitable giving. And together we'll talk about how thoughtful planning can support your loved ones, sustain peace building over the long term, and how easy it can be to get started no matter your age, your income, or your family situation. As we go through today's conversation, feel free to drop any questions you have into the chat at any time, and we'll make sure to get to as many of those as we can during the Q&A portion at the end. But with that, I'll pass it over to you, Chuck. Welcome. I'm unable to hear you, Chuck. Oh, there we go.
Can you hear me now?
There we go. Yes, now we can.
Sorry about that. Well, thank you, Alicia, and thanks to everybody for joining us today. As Alicia said, my name is Chuck Borick. I'm an attorney with FreeWill. I'm general counsel with that company. Prior to that, I practiced in the estate planning and tax field for approximately 30 years. And today we're going to talk about estate planning sort of at a 30,000 foot level, right? We're going to talk about the basics and what I think everybody should know about estate planning. And we're going to start with, why estate planning matters. The two most common myths that I come across with respect to estate planning is that it's just for older people, just if you're ready to die, that's when you need a will, or it's just for the wealthy. Well, neither of those things are true. First of all, generally, most of us don't know when we're going to die, right? It could happen at any time. We usually don't have it scheduled out. And secondly, estate planning has a lot to do with a lot of things that aren't just dealing with wealth. So what is estate planning all about? Well, it's about the general choices you make about how your property is going to be transferred when you die. When you die, assuming you own some property, something's got to happen to that property. For most property, it doesn't happen automatically. Now, there's certain types of property, if you own jointly or with right of survivorship or in certain other ways the property is titled, it's possible that property would transfer automatically upon your death. But for any property that you just own outright in your own name, there has to be a mechanism for doing that. And more specifically, there has to be some direction for doing that. And that direction is either going to come in a testamentary document that you do yourself, or it's going to come from the state. One of the things that I used to tell my clients when I was in private practice is that everybody has a will, right? You either have a will that you've done for yourself or that someone helped you to do that specifies your personal desires about how your property is transferred upon your death and how things are taken care of, or you have the state's will, because in every state we have what are called laws of intestacy. And the laws of intestacy basically serve as your will if you die without your own personal will. The problem with that, of course, is that the choices the state has made for you might not be the choices that you'd make for yourself. So for that reason alone, it's good to have your own will. Also, if you have minor children, the will is the place where you can select the guardians to take care of your minor children if you and the other parent of the child is deceased. The state doesn't do that. The state will have some sort of a guardianship proceeding, and those can get really messy, and your children could literally, in the worst case scenario, end up in foster homes, and there's all sorts of bad things that can happen. So certainly, if you have minor children, again, if for this reason alone, it's a good idea to have a will so you can name the guardians for your minor children. Estate planning is also about planning for incapacity. Especially as science and medicine have progressed. The life expectancy has increased, and many of us will live many, many years, oftentimes for many years beyond our ability to really effectively manage our own affairs and manage our own property and manage our own health care even. Estate planning can put mechanisms in place to assist in that area as well. Caring for pets. This is one that people often don't think about at all. If you have pets, many of us have pets that we love and cherish. Well, you can't assume that your pets are going to, meet their demise before you do, or will meet their demise at the same time, right? So if your pets are healthy and living at the time of your death, what's going to happen to them? Well, the sad fact is many pets will go to a kill shelter, if you haven't made some sort of arrangements for them. And so you can do that with estate planning. You can protect assets with estate planning. Perhaps you have assets that you want to go to your adult children. Maybe your adult children are married. Maybe their marriage isn't so great. Maybe you're concerned that their spouse might end up inheriting your property, and you don't necessarily want that to happen. Well, you can put in protections so that, to make sure that your assets are only used for your children and your grandchildren, for example. So there's all sorts of things you can do. Another thing you can do that's not on the screen is you can give gifts to charity. Upon your death, if you don't have a will, there's no ability. In fact, there's no legal mechanism for taking any of your property and giving it to charity. And so if you have a will, you can certainly include charities in that will. And there's all sorts of different ways of doing that, by the way. You don't have to be wealthy to do that. You can have contingent gifts to charity. There's all sorts of ways that you can, provide for organizations that you feel are close to your heart, and organizations that you want to support, regardless of your level of wealth. So let's talk about plan giving. Plan giving, of course, deals with giving to charity, and giving to charity in a very deliberate and planned way. And to start talking about plan giving, we need to understand some basic fundamentals about property, right? Because that's what we're talking about. We're talking about transferring property of one sort or another to charitable organizations. Property comes in two flavors and two flavors only. There's real property and there's personal property. Real property is dirt and things that are permanently attached to dirt, right? Buildings, for example, okay, and any other improvements. That's what real property is. Everything else is referred to as personal property, right? So personal property doesn't mean things that you just, personally use, as opposed to business property, for example. Personal property means any kind of property that's not real property. So it includes cash, it includes things like, automobiles and paintings, and even things like insurance policies and contract rights can sometimes be personal property. So those are the kinds of property we're talking about. The other thing that you need to know is the different ways of owning property. Now, this varies a little from state to state, but there's some basic kinds of property ownership that you should be aware of. The most basic kind is just when you have sole ownership of property. It belongs to you and only you. You're the only owner and you own it completely. In the law, we sometimes refer to that as fee simple or fee simple absolute ownership. We usually use those terms when we're talking about real property, but theoretically, those terms could apply equally to personal property. Another type of owning property is concurrent co-ownership, meaning that somebody else has an interest in the property along with you during your lifetime, and there's different flavors of that. You can have joint ownership with right of survivorship. I mentioned that briefly earlier. That's the type of ownership that when you die, the property automatically passes to the other joint owner or owners. You can have tenants by the entirety's property in some states, not all states, but in about half the states, they recognize tenancy by the entireties. And that's a type of ownership that can only occur between married people. So only a married couple can own something as tenants by the entireties. Tenants by the entireties is very similar to joint tenancy with right of survivorship. There are a few technical distinctions there, but it's very similar to joint tenancy with right of survivorship. You can own property as tenants in common. That means that multiple persons own the property, right? Two or more persons own the property, but your share of the property can be passed in your will. In other words, there's no right of survivorship. When you die, your share of the property goes to whatever your will says, or if you don't have a will, the laws of intestacy. Some states have community property regimes. Community property is basically a way of looking at property between married couples and treating it as if both members of the marriage, both persons in the couple, equally own all of the property that is obtained during the marriage. There's only 9 states that have community property. They're mostly out west: California, Nevada, Arizona. I could probably name all 9 if I had to, but we'll forego that for now. Um, Joint tenancy with the right of survivorship and tenants by the entireties is what we call non-probate property because, as I said, it passes automatically. So if you want any property, your house, your car, or anything, to automatically go to somebody, you could name them as a joint owner with right of survivorship. Or if you're in one of the states that recognizes tenancy by the entirety, you own something jointly with your spouse, it automatically goes to your spouse upon your death. With tenants in common and with community property, your share of the property is yours to do with what you want upon your death, right? In other words, it becomes part of your probate estate. And then finally, there's successor ownership. This is ownership that happens after either a period of ownership or somebody's life. The most common example of successor ownership are beneficiary designations. So if you have a retirement account or a life insurance policy, you've probably designated a beneficiary, which means it will automatically go to that person upon your death. With bank accounts, we usually call them transfer on death accounts or TOD accounts. And you can have other mechanisms of successor ownership, such as life interest, right? So you can have property where you own it for your life, but then upon your death, or upon somebody's death, it doesn't even have to be you, it goes to someone else. Also, trusts are a way of setting up successor ownership where one party has the benefit of the property for a certain period of time or perhaps for their life, and then other people that we call remainders or remaindermen take the property upon some event. What is probate? Well, probate simply is the process of transferring your property upon your death. In order to transfer property, certain legal requirements have to take place. In some cases, such as with real property, yeah, the person transferring it has to actually sign a deed. Well, signing a deed becomes, very difficult after you've died. Right? And so we have to figure out, well, how can we transfer the property if the owner has to sign a deed and the owner is dead? Well, we do that through the probate process, right? In the probate process, somebody files a petition for probate, typically the executor or personal representative named in the will. And then there's a series of steps. There's notices that are published. The person who's named as the executor has to file an inventory to let the probate office know what property was owned by the decedent. They're responsible for collecting any income during the probate proceeding, paying any debts and expenses. They have to file accountings to make sure that they're doing everything the way they're supposed to. The probate process allows you to resolve disputes. It's a form for doing that. And then finally, at the end, there's a final accounting and a distribution. That's the basic way probate works. Now, again, every state has its own probate office. They're called different things in different states. And their specific procedures, vary a little from state to state, but that's the basic way probate works. Now, some people say, well, probate's a terrible thing. In 1968, a fellow by the name of Norman Dacey wrote this book you see on the left, How to Avoid Probate. And in that book, which I have up on the bookshelf behind me, Norman Dacey says that probate is the most awful thing ever devised by mankind. That you should always avoid it, that it is horrible, it's corrupt, it's just a way of lining politicians' pockets. Well, I wasn't practicing law in 1968, so I can't speak directly to what Mr. Dacey was referring to, but I can tell you that today that's not the case. Okay. Probate can be bad. Yeah, if you have a complicated estate or complicated situations, probate can be complicated. Probate can also be very easy and simple, and actually, probate can be a very good thing. It has some things that are very good about it. Such as the fact that the probate court oversees what's going on and makes sure that what's supposed to happen actually happen. So you can avoid probate, however, by using this thing called a living trust. A living trust is a way of setting up a trust during your lifetime. It's technically called a revocable living trust or an RLT, and you can put all of your assets into that trust. And the way the law works is, if you've done that, if you've put all of your assets into the trust, then when you die, you don't own any assets. The trust owns the assets. So there's nothing to probate. The trust instrument, the trust document, will say what should happen to those assets. In other words, the revocable living trust itself substitutes for a will. So is this a good idea or a bad idea? The answer is it's neither. Revocable living trusts are perfectly fine. They do, work as intended, and there are certain reasons you might want to have a revocable living trust. If you want to have privacy, if there are several other conditions that might make you desire to have a revocable living trust. Revocable living trusts are a lot more work up front because you got to transfer everything into them. If you fail to transfer everything into them, they're no good at all. So you have to transfer everything into them. That can be a lot of work and a lot of headache. But they're perfectly fine and they do work. And in my practice, I use both revocable living trust-based plans and will-based plans. In my opinion, neither one is better than the other. It depends on your situation, right? One or the other might be better for you in your particular situation, but neither one of them is implicitly better, right? And so the two books that I'm showing you there are just the two sort of ends of the spectrum, right? The how to avoid probate, because probate's a terrible thing at all costs, you should avoid it. And then you see this other book called Living Trust, Living Hell, which argues that living trusts are terrible and much worse than probate. Again, in my opinion, neither one of those extremes is really accurate. I want to talk about some tax basics. First of all, let's talk about the types of tax there are. There's lots of different types of tax. When we talk about tax, we most commonly are probably thinking of income taxation, right? So as you know, the federal government has an income tax, and most states, not all, but most states have a state income taxation. Um, Income taxes are imposed on what the law calls accretions of wealth. And what that basically means is anytime something happens that makes you economically better off in a tangible way, well, that's income, right? So types of questions I often get asked are like, well, gee, if I win a prize, if I win a prize at a drawing, a raffle or something, is that taxable? The answer is yes. If my employer decides to send me on a weekend trip to the beach because I've worked so hard, is that taxable? The answer is yes. Basically, the way the tax code works is that any accretion of wealth is taxable to you unless there's a specific provision in the tax code that says it's not taxable, right? And there's lots of those provisions, right? So things like health insurance aren't taxable, and all sorts of other things may not be taxable. But we'll always start out with the basic premise that if you're better off economically in a tangible way, meaning in a way you can spend it, it's probably taxable income, unless we can find a provision that says that particular type of income is not taxable. Things that you can't readily spend, like the value that your house goes up in value, that's not taxable because that's not tangible accretion of wealth. A separate type of tax is the estate tax. That's a tax imposed on your estate, and it's specifically imposed on the transferring of wealth. Now, there is a very high, generous exemption from the federal estate tax, right? So if you die owning less than $15 million, and that amount goes up with inflation every year, If you die owning less than $15 million, then there's no federal estate tax. And in fact, if your spouse dies first and they didn't use any of that $15 million, then you have 30 million that you can pass without any federal estate tax. Now, some states, again, not all, there's only a handful of states that have a state estate tax, but there are some states, and their exemption tends to be a lot lower. So it's not 15 million, it might be closer to a million or 5 million. So it's possible that with a more modest estate, you might still have state estate taxes that are imposed upon you. Now, the gift tax is separate from the estate tax, but we often think of them together because they are coordinated. Only one state has a gift tax, however, that's Connecticut, but there's a federal gift tax. The gift tax is imposed on the donor, the person giving the gift, which seems sort of counterintuitive, right? We typically think of tax as something that's imposed when we get something. Gift tax is imposed when you give something. Why is that? Well, it's meant to be sort of a backstop to the estate tax. When Congress first enacted the estate tax, they realized that if people were clever and careful, they could devise ways to gift away all of their property just before they die. And if that happened, then there would be no estate to tax, right? Because all their property would have been gifted away. So Congress said, all right, well, we're too clever for that. We're going to impose a gift tax. So if you give away property during your lifetime, then we're going to add that back to your estate essentially, so that the gift itself will get taxed. Now, there are lots of exemptions to the gift tax. There's an annual exemption where you can give approximately $20,000 a year away to as many people as you want, gift tax free. There are all other exemptions, like you can give as much to your spouse as you want, and that's gift tax free. And there are various other exceptions like that, but that's what the gift tax is. And then finally, there's an inheritance tax. Some people confuse the estate tax with the inheritance tax. The inheritance tax is different because the inheritance tax is imposed on the recipients of property from your estate. All right, and now it's not imposed on everybody. The states that have this, and there are only a few states that have it, and the federal government does not have an inheritance tax. The states that have it generally impose it only on what we call collateral beneficiaries. That means beneficiaries who are not part of your immediate family. So usually there's no inheritance tax if something going to your immediate family. But if you have beneficiaries who are cousins or who aren't related to you at all, there may be an inheritance tax on them when they receive the property. In order to demonstrate for you how planning can make a big difference and how charitable giving can be part of that planning and make a big difference, I want to just go through quickly with you a typical property transaction and how it's taxed. So you put money up to buy some property, whether it's a house or stock or cryptocurrency or art or antiques or whatever. The money that you use to buy that property, the amount of that money is referred to as your basis. That's your basis in the property, basically the amount of your investment in the property. Someday, assuming that you decide to sell the property, you're going to put that property up for sale. And whatever you get in the sale are the sales proceeds, right? Now, the sales proceeds are an accretion of wealth, but they're not 100% an accretion of wealth, right? Because part of it is just getting back your basis. Part of the sales proceeds are just paying you back for what you paid originally to buy the property. So that part's not taxable. The part above your basis, right, assuming that you do in fact sell the property above your basis, that part above your basis is referred to as the gain, and that part is taxable. Now, if you've held the property for a year or more, that gain is taxable at special favorable, what we call capital gains tax rates. Right? Again, you have to have held the property for a year or more, but as long as you've held the property for a year or more, the property is generally going to be taxed at 15% or possibly 20%, depending on what your total income is. For most people, it would be 15%. It could even be 0% if your income is low enough. But that's as opposed, for example, to the ordinary income tax rates, which might be as high as 37%, right? So the capital gains tax rate is always lower than your regular ordinary income tax rate. Now, if you have property that has a lot of gain in it and you're philanthropically inclined, One way you can avoid paying any tax on that gain and doing something good for your favorite charity is you can gift that property to charity. When you gift the property to charity, not only do you get a tax deduction for the full fair market value of the property in most cases, you don't have to recognize any capital gains, so you don't pay any tax, and the charity doesn't pay any tax because it's nonprofit and tax exempt. So you can transfer lots of gain. If you bought a house, back in the 1950s and you paid $500 for it, and it's now worth $1 million, you could transfer that house to a charity. You don't have to pay any taxes. You get $1 million tax deduction, and the charity gets $1 million house. So, gifting appreciated property to charity, can be a good idea. What you don't want to do is if you have appreciated property and you want the value of that property to go to charity, you don't want to sell the property first and then give the money to charity. Because if you do that, you got to pay tax on the gain when you sell the property, right? It's better just to gift the property itself to the charity. I've mentioned trusts. Trusts can be a magical thing, especially in estate planning. A trust is basically a method of holding property. All right. When we own property, any kind of property, there are two fundamental aspects of that ownership. There's what we call the legal ownership and the beneficial ownership. When we think about owning property, we generally own both together. All right. We own the legal title, which means we can do whatever we want with the property. And we own the beneficial interest, which means that whatever we do with the property, we can do it for our own benefit, right? So those two natures of property are generally joined together when we think of property ownership. However, the law allows you, if you're going to transfer the property to somebody, the law allows you to take those two aspects and separate them. And you can give the legal title to the property to one person, who we call the trustee, and the beneficial title to the property to somebody else, the beneficiaries. So the trustee is required to manage that property, but manage it solely for the benefit, not of the trustee, but for the benefit of the beneficiaries. So that's just a basic concept in the law, and trusts are used for all sorts of things, not just estate planning. But certainly there are many uses for them in estate planning. When I talked about the revocable living trust earlier, that's what it is. It's a trust. With a revocable living trust, specifically what you do is you name yourself as the initial trustee, and you name yourself as the initial beneficiary, but then you have to name other beneficiaries as well. Those would be the people who take the property upon your death. But it's just a trust like any other trust. Um, how do we use trusts? Well, in estate planning, we can use them to manage property that's going to minor children. If you have minor children, or even if you have adult children, if they're not particularly good or not able to manage property by themselves, well, rather than putting it into their hands and having them, sort of maybe do things that aren't so responsible with it, you can put it in a trust. And the trustee can manage the property. The trust document can give the trustee instructions as to when and how they can make distributions to the beneficiaries. For example, if you have minor children, you can set up a trust that has the trustee manage the property until the children reach a certain age, 25 or 30 or whatever age you pick, and then the property can go, whatever's left can go to the children. Sometimes you have property and you say, well, gee, I want the income from this property. Maybe you have a rental property, right? And you say, I think my beneficiaries should hold this property for 10 years after my death, and I want all the income from that rental property to go to one person, but then after 10 years, I want it to be sold and I want the proceeds to go to somebody else. Well, again, you can use a trust to effectuate that. An irrevocable trust that you create during your lifetime removes assets from your estate. So if you have a potentially taxable estate, you can take some of your property, put it into an irrevocable trust, and it's just like giving the property away, but you still have control, right? Because you can put the instructions in the trust document as to how that property can be used. And so you don't have to actually put it into the hands, for example, of children that you think might not use it wisely. So for maybe you have children, you say, look, I want to make sure these assets are used for my children's education. I don't want my children to decide, gee, I have all this money now, I'll go take a trip around the world. Or buy a fancy car or something. And so rather than giving it to my children directly, I'm going to put it into a trust. I'll have the trustee instructed to use it for their education, and at a certain age, it can go out right to the children. And then we also have the things like the revocable living trust, which I talked about earlier. In terms of using trust in planned giving, there's three very common kinds of trusts that people use. And I think it behooves everyone just to have a basic understanding what these trusts are. There's something called a charitable remainder trust or CRT. There's something called a pooled income fund, which is basically a variation on the charitable remainder trust. And then there's something called a charitable lead trust. And I just want to show you briefly how those things work. Let's start with the charitable remainder trust. So you're a person and you have some property, maybe some cash, real estate, stocks, crypto, whatever it is. What you can do if you want that property to be used for charity and you want to still benefit from the income that the property generates or the income that it could generate if it were liquidated, you can put that property into a CRT, a charitable remainder trust. And when you do that, the economic streams from the property are divided up into two different parts. The first part is called the lead interest, or sometimes the income interest. So that income interest or that lead interest can be distributed back to yourself or to whoever you name as beneficiaries, maybe your children or others. They have the only limitation is the folks that get the annual distributions from a CRT cannot be charities, right? They have to be non-charitable beneficiaries. So they get annual distributions for a period of years. It could be for the rest of your life. It could be for a period of years up to 20 years. And then at the end of that period, whatever is left over goes to the charity. The remainder goes to the charity, hence a charitable remainder trust, right? So that's a way of uh, giving basically a delayed gift to charity, and during that delay period, using the income from those assets to benefit again yourself or others that you name. That's a charitable remainder trust, and again, you get a tax deduction for the value of that remainder. Pooled income fund is very similar. The only difference is rather than setting up a separate trust just for you, a pooled income fund is basically an aggregate trust. These are things that charities themselves set up when they have people who don't maybe have enough money to warrant setting up their own separate charitable remainder trust. They can have this sort of pooled trust that anybody can donate to, and it works the same way. Depending on how much you donate, that determines how much you get in annual distributions, and then at the end of the trust term, the remainder goes to the charity. A charitable, whoops, let me go back here. A charitable lead trust is basically the same as a charitable remainder trust in reversed, right? So rather than the remainder going to charity in a charitable lead trust, the lead interest or the income interest goes to charity, and the remainder goes to whoever you name, your children, for example. That's a very common setup. So those are the three basic kinds of trusts that are used in charity to make charitable gifts: charitable remainder trust, charitable lead trust, and that pooled income fund. Charitable gift annuities. Well, you may be familiar with annuities, right? Insurance companies and others sell annuities. Insurance companies are the big providers of annuities. And an annuity is something people sometimes use for retirement. Basically, the way an annuity works is you invest a lump sum, and then the annuity company, typically the insurance company, agrees to pay you back a certain amount every year for the rest of your life, right? So with an annuity, of course, there's always risk, right? You might outlive the annuity and get back more than you put in. And on the other hand, you might, pass away the next year and not get hardly anything out of it. That's sort of the nature of an annuity. Well, rather than buying an annuity from an insurance company, you can basically buy one from a charity too. And the way it works is you make this lump sum transfer to the charity, and the charity agrees to give you periodic payments for the rest of your life. Um, and again, that's a way of giving to charity and still not completely letting loose of those assets. You still get to benefit from them for the remainder of your life. There's something called qualified charitable distributions if you have an IRA. Um, now, there are a couple of requirements for this. You have to be at least 70 and a half years old before the end of the year in which you undertake this qualified charitable distribution. And basically what it is you instruct the custodian of your IRA to make a transfer directly to a charity. In other words, the money doesn't come out to you yourself, but it goes directly to the charity. Now, why would you want to do such a thing? The main reason is because that amount that goes directly to the charity counts as your required minimum distribution. So it never has to pass through your hands, so you don't pay any tax on it. Um, you meet the requirement of the law if you're of a sufficient age that you have a required minimum distribution, and the money can go into charity, benefit the charity, and it doesn't have any negative tax impact on you. There are some other requirements. The charity can't be a private foundation; it has to be a public charity. It can't be a donor advised fund, right? That's a fund that you establish with a charity for future gifts. And it can't be what's called a supporting organization, basically an organization that only is tax exempt because it supports other organizations, right? So there are some restrictions on qualified charitable distributions, but if you're over 70 and a half and you have required minimum distributions that you don't need for your own use and that you don't want to have to pay tax on, you can have those required minimum distributions go to charity. I mentioned donor advised funds. So let me show you how a donor advised fund works. Basically, and any charity can set up donor advised funds, but there are certain charities that sort of specialize in this. The way it works is you make a gift to the charity, you get a tax deduction for that gift, but the charity, rather than using it immediately, holds on to it. And you're allowed to make recommendations as often as you like as to how that charity will use the money. In other words, what other charities they will grant it to. Typically, the charity that sponsors the DAF doesn't have any operations itself. It makes grants to other charities. So you can recommend what charities you want them to make grants to and in what amount. Now, your recommendations are just that, right? Under the law, once you transfer that money into the DAF, then the charity owns it and they can do anything they want with it. But obviously, charities set these things up because they want to, fulfill your wishes. So unless your recommendation is something that's illegal or something that they're not lawfully allowed to do, they're most likely going to abide by your recommendations and provide that money to charity. So you could, for example, give $100,000 to a charity and then say, all right, well, this year I want 10,000 to go to the American Red Cross, and next year I want another amount to go to some other charity, and uh, you can make those kinds of recommendations. That's what a DAF is. So having said all of that, let me tell you about the company I work for. I work for a company called FreeWill. FreeWill is what's called a public benefit corporation. And that means that although we're a for-profit company, we're not a nonprofit, we're not a charity, we do have certain public benefit missions that don't make any money for us necessarily, but that we think are important things to benefit the public. And our public benefit missions are to increase the number of people who have estate planning documents because we think that's a good idea. And also to try to increase and encourage people to make bequests and gifts to charity because we think that's a good idea too. We have a free public-facing website. It's freewill.com. It is absolutely free. You can go on freewill.com and you can do a will. You can do other documents as well. You can do a power of attorney. You can do an advanced healthcare directive. You can't do a revocable living trust unless you live in California. But you can do a will in every other state. Um, and it's free. It's literally free. We don't ask for your credit card number. We don't, it's just a free public service, just freewill.com. So if you don't have a will, and you don't want to see a lawyer, by the way, we're not lawyers. I'm personally a lawyer, but my company doesn't practice law, right? FreeWill doesn't practice law. It's always best, all things being equal, to see a lawyer. However, some people maybe don't have the funds to see a lawyer, they just don't want to see a lawyer, or they don't have time to see a lawyer. If you're in any of those cases and you want to have a will, well, go to freewill.com. And at least, even if it's just a temporary one until you get a chance to go see a lawyer, at least you have something. And it will walk you through all the decisions that you should be making. We also have nonprofit partners. That's how we make money. We consult with nonprofit organizations, and they buy packages from us that facilitate their donors making wills and revocable living trusts. And other estate planning documents. It is simple. It's easy to use. You can make a will on freewill.com in about 20 minutes. It's not designed for complex situations. Okay. Again, we don't give any legal or tax advice. If you need legal or tax advice, you should see a lawyer or a tax advisor. All right, we make no bones about that. We are not a substitute for lawyers. We're a substitute for people who don't have lawyers or don't want lawyers, but still need an estate plan. So, our target audience are those folks who aren't going to go to a lawyer and therefore won't have an estate plan unless they go to, a free site like ours. Um, we also do things like facilitate stock gifts. Some nonprofits aren't set up to receive stock gifts or crypto gifts. Um, we facilitate that, so we can make that happen. So if you have cryptocurrency and you want to give it to your favorite charity, and your favorite charity says, we're not set up to take that, we can facilitate that. We can liquidate the crypto and give the charity the cash. We can also facilitate the DAF distributions I talked about, and the QCD distributions as well. All right, finally, I want to talk about some recent changes. There were some recent changes in the most recent tax legislation that was passed. That $15 million estate and gift tax exemption I told you about, that was made permanent, right? It had gone up and it was scheduled to go down in 2026. Not only did it not go down, but Congress increased it to $15 million per person and made it permanent. You hear a lot of talk about the estate tax, but because of this very large exemption, and the exemption has been very large for many years now, actually very few estates end up having to pay at least the federal estate tax. And again, not many states have a stated estate tax. But the statistics are something like 3,000 to 4,000 estates in the whole country every year might be subject to the federal estate tax. So most people do not have to deal with the federal estate tax, but if you're, have a significant amount of wealth, you may have to. The charitable contribution deductions until 2026 are only available if you itemize the deductions on your tax return. However, starting next year, you can take what we call an above the line deduction, meaning you don't need to itemize in order to take this deduction. And you can take a deduction of up to $2,000 on a married joint return, or $1,000 if you're filing a single return or a married separate return. And you don't have to itemize to do that. So that's an opportunity to actually deduct some of the money you're giving to charity, up to $2,000 for a married couple, without having to itemize. On the flip side, there are some restrictions for those who do itemize. There's now what's referred to as the 0.5% floor, meaning that the first 0.5% of your adjusted gross income, that's what AGI stands for, is not deductible as a charitable contribution. So, for example, if you have $100,000 of adjustable gross income, 0.5% would be $500. That means the first $500 of your charitable contributions, if you are itemizing, the first $500 would not be deductible. You would only get to deduct charitable contributions above that amount. Now, again, if you're not itemizing, you can deduct $1,000 or $2,000 if you're married without having to itemize. All right. Well, that's sort of a whirlwind tour through estate planning. I know we talked about a lot. I know some of it's a little complicated, but I wanted to give you a flavor of the available resources and encourage you to think about estate planning and to do it one way or another if you haven't done it already. And that's all I have.
Thank you so much, Chuck, for all of that really helpful information. Hearing how planning can make a difference really puts things into perspective. So we appreciate all of that information. But to show you what impact can look like in real life, I actually want to share a story about someone whose life and community has also been transformed over time. In 2011, a young man named Thiru almost left his hillside country hometown in Sri Lanka in search of opportunity. But during a holiday visit, he actually joined Search on Sri Lanka's first youth project, and everything really changed there. So what started as a training in basic civic skills grew into something much bigger, really empowering young people to claim their rights and strengthen their communities. Thiru's youth club helped plantation workers access retirement funds without exploitation, earning trust and sparking real change. And today, 14 years later, that work continues under the program We Lead Lanka. Thiru now leads a team, has an office space, and even partners with other NGOs, estate managers, and local governments to keep opening doors for marginalized communities, from addressing gender-based violence to nurturing young leaders. He actually said that just like Search did 14 years ago, they also tried to do meaningful and sustainable work. So stories like Thiru really show how long-term support, including gifts and estate plans, can help individuals and communities thrive for years to come. And by creating an estate plan, you can protect the people you care about most, gain peace of mind, and even support people like Thiru in building brighter futures. When you include search in those plans, you're helping build a future where conflict gives way to collaboration, where communities thrive, and where peace isn't just hoped for, but it's made real. And so we invite you to take that step today and let us know if we can support you along the way. Um, I'd love to hear from you all. We'll start with just a question that I often hear from donors. And then we'll get to some others from the chat if they've come in. If you have any other questions, feel free to put them in the chat and we'll try to get to them today. If not, also happy to answer any of those through email. The first question for you, Chuck, is many people hesitate to make an estate plan because it can feel overwhelming. There's a lot of verbiage. It seems very complicated. Well, in your opinion, what is, the first step you'd recommend to even get started?
Well, not surprisingly, I guess I would recommend going to FreeWill, because FreeWill will walk you through the process. It'll show you what it's like. Even if you just go to FreeWill to get acclimated to what it is, even if you're planning to see a lawyer and you just want to know sort of what kinds of things you should be thinking about, you can go on freewill.com, through Common Ground's website, search for Common Ground's website, or just through freewill.com, see what types of questions you should be thinking about, and just acclimate yourself to that. And, if you, as I said earlier, if you want to have a will, as sort of a temporary thing until you have a chance to see a lawyer, you can even create a will if you like. And as I said, it's simple. It takes about 20 minutes. It's really not that, all we've done is we have used the fact that everybody has always been able to make their own will. In this country, you've always been able to make your own will. There's no requirement that a lawyer do a will. You can do your own will. The problem is if you sit down at your kitchen table with a pad and a pencil to make your own, you probably don't know where to start. Well, that's where FreeWill can sort of help you out. So that's what I would suggest.
Yeah, I would like to echo that. It does make it very simple, and we've had already quite a few people mention that they are including search through FreeWill, which is a great tool. Another question for you is, how do you suggest families even start the conversation about legacy giving without it feeling awkward, which I've personally experienced with my own family, and I know it can feel a little touchy.
Sure. Well, I'll tell you what I used to tell my clients is, estate planning and legacy giving is really a personal thing, right? So you don't necessarily have to share the details with anybody, right? If you don't feel comfortable doing that, but you can sort of have conversations to try to ascertain, like, what are your loved ones' expectations? There's certain things that you own that they are hoping or expect to inherit someday, or you can sort of gather information without necessarily having sort of a powwow where you sit down and say, okay, you're getting this and you're getting that. You don't necessarily have to do that, but you can find out, and explore your own feelings about what you would like to have happen to your property, and how you would like to take care of your loved ones. And you sort of sort through that in your mind, and come up with a solution. Now, for some people, they do want to talk to everybody and they want to get everybody's input, and they want to specifically say, hey, I'm doing my will and I'm trying to figure out what it is that your expectations are. And you're free to do that if you'd like to, whatever works for you. But I think the main thing is just to dive into it. It's like when you go into the pool, and it's a little chilly, and you step in, you think, well, this feels cold, and you sort of don't want to go in. The only way to do it is just got to dive in, right? You
Right.
dive in, you go in, and then you're fine. So just start somewhere, I guess, is the main thing I would say.
Agree. We have another question in the chat. We were asked if Search for Common Ground is eligible for QCDs, and the answer is yes. And as Chuck mentioned before, if you're 70 and a half or older, then you can make a donation directly from your IRA to Search for Common Ground using a QCD. And these gifts count towards your required minimum distribution and are generally excluded from your taxable income. So it's also a really super simple and tax efficient way to support our work and make immediate impact. So that was another question that came in. But with that, thank you, friends, for submitting these thoughtful questions, and any of the ones that were asked in the chat that we didn't get to, we'll send you an email. Chuck, thank you so much for the information that you shared today and all of those insights. But before we wrap up, I just want to make a quick plug for an easy and beautiful way to support Search right now is through our Love Anyway shop. It's full of beautiful artisan-made items that support individuals and communities affected by conflict, and every purchase helps fuel this work and invest in peace. So you'll find the link in the chat, and it's a small thank you for spending time with us today. We're going to be offering you all 25% off with the code LEGACY on your next purchase. So please take a look, and I'm sure you'll find something that speaks to you. There's also 2 upcoming virtual events, really great opportunities for you to stay connected with our work. The first is Thursday, October 16th, and we'll be continuing our Ask Me Anything series with our CEO, Shamil, and he'll share updates from our work and insights on peace building, and of course, answer any of your questions. The second one is on Thursday, November 13th, for our final event of the year, The Power of Us, Confronting Hate and Polarization in the US. And we'll look at the rise of hate and polarization with Neelan Parker, who is our Common Grounds USA director, and explore the powerful ways each of us can help build social cohesion and chart a different course for our country and in our world. But thank you all so much for joining us today, for your time and for your curiosity, and as always, for your dedication to building peace and for the ways that you're leaving a legacy that will impact generations to come. If you have any questions or would like support as you think about your own plans, please don't hesitate to reach out to us at plangiving@sfcg.org. That's in the chat. And we're here to help you through every step of the process. But thank you all again, and we'll see you next time.